you. Welcome. Thank you for attending the second of 4 programs on the commercial division in the New York State Supreme Court. Today's program is on depositions. The speakers are Sandra Goldstein, Stefan Atkinson, and Robert Gretch, and they're all partners of Kirkland & Ellis. Their firm bios span 24 pages, which I will not be repeating here. But suffice it to say, they have worked on some of the most exciting, important corporate litigation involving contemplated and hostile takeovers, cutting-edge issues like de-SPAC mergers, and involving companies we've all heard of, from Barnes & Noble to Xerox, Grubhub, Heinz, Qualcomm. And it's my privilege to join that panel today. Before we get to our multimedia presentation on depositions, I'd like to remind you about the commercial division, where I am one of 27 judges in the state of New York assigned to work in the commercial division. I'm an elected judge in Manhattan, where we have 8 of the 27 commercial division judges. We each have dockets of about 300 to 400 cases, and each docket is entirely commercial in nature. Last week, we reviewed examples of commercial cases, and for more information about the commercial division, I urge you to visit the website. The Commercial Division Advisory Council's video is on the Commercial Division's website at nycourts.gov. If you are as fascinated as I am by the cases discussed last week and at today's program or the upcoming programs on electronic discovery or trials, then I hope you'll think about joining us either as an intern or a law clerk. Law clerk positions are regularly available as law clerks come and go at various times. So please visit the website. Again, it's nycourts.gov. It's also on Twitter and Facebook. Anyway, so please visit the website, and you'll get some more information about each of the judges, instructions on how to apply to each of the judges, to contact any of the judges, or to find out our rules or practices on open positions. You would look at each individual website or web page, and the open positions are also posted on nycourts.gov/careers. So with that, I'll turn it over to my colleagues for a discussion of depositions, a crucial part of the litigation process.
Thanks very much, Justice Masley, and it's our honor to present with you today. So thanks for doing this with us, and definitely, I think, note to all of ourselves to potentially shorten our bios. So we'll get right on that. So as Justice Masley said, today we are going to talk about depositions, the purpose of a deposition, some tips on preparing to take a deposition, defend a deposition. Because obviously taking and defending are the opposite sides of the coin, and both incredibly important pieces of what you do as a litigator. So let's start with the purpose of the deposition. So what is a deposition? Before a case goes to trial, there's the discovery phase of litigation, and that's where the parties are exchanging evidence. They're exchanging documents back and forth, and what you do early on in the case is share with the other side the names of the witnesses that have knowledge of the key events in the case. And of course, sometimes you learn later that there are other folks as well, and those get revealed in due course. But it's really, really important to, when you get those names, that's when you start to think about, okay, who do I want to depose here? And we'll get into tactics and strategy a bit down the road. But what is a deposition? It's sworn testimony. It typically takes place in a conference room somewhere. There are lots of lawyers. There's a lawyer for the witness, and certainly lawyers from both sides. There's no judge present. So this is one big difference between testimony in deposition form versus trial. Obviously, where a judge is present. So there's no judge present, which we'll talk about as well. And there's a court reporter who takes down verbatim the transcript. I still find it amazing how they can write down through stenography everything that's going on. It's an amazing skill. But there's a court reporter that takes down everything. Now, these days, by these days, I mean last couple of decades, I'm showing my age here, there's almost often, I won't say always, but often a videographer as well. So in addition to the court reporter who's taking everything down in dry transcript, there's often a videotape these days. And it's important to decide whether you want that or not, because it's, as I said, transcript is dry. And so you can read a transcript, but you won't necessarily see the witness's facial gestures or hear the tone, or frankly, hear the tone of the lawyers. And sometimes, as I believe Justice Masley will talk about in due course, it's important to see that, for a judge to see that, for a jury to see that, to decide credibility and other issues. So, one thing, right off the bat, we'll talk about a decision to make is whether you want to be videotaping your depositions or just have the dry transcript.
Can I just follow up on the dry
Please.
transcript? And I know we'll get to strategy later, but when you see a jury, which is one of the uses of a deposition, when you see a jury watching a video of a deposition as opposed to reading the transcript, the dry transcript, what a difference. You see them sitting on the edges of their seats.
Right. No, it's huge. And obviously I'm sure you'll say you don't play hours and hours of the tape because then they'll get bored. But when you can distill in 5-10 minutes key pieces of videotape, it's often quite effective for the jury. So turning to who can be deposed. So parties can be deposed, obviously, individual parties. So if it's a named individual, or often we obviously have companies who are parties in these cases, and you can have executives or employees of that party, if they have personal knowledge of the issues, deposed as well. And in that case, they're being deposed. They could be deposed in their personal capacity. Alternatively, for companies, you can have a corporate representative who speaks on behalf of the company. So it's basically you're serving a subpoena on the company itself, saying, give us the person most knowledgeable. And then that person on X, Y, and Z topics. And then that person speaks on behalf of the entity. So sometimes the witness who's sitting there is being deposed in their personal capacity, and sometimes they're being deposed in their capacity as corporate representative. Different rules for that, different rules for preparation for that. And so you always have to be mindful of, who is this deponent and what is the purpose that they're serving, to know how to prepare them, or of course, how to take the deposition. Of course, experts, you have experts in cases and they get deposed, and you can have a non-party witness who's subpoenaed, who will testify as long as all the parties get notice. And a lot goes into the tactics and strategy of how many depositions you want, who you want to have deposed. Always have to think about, it's kind of, I think of it as goose gander. What's good for the goose is good for the gander. If you're going to ask the other side for, 20 more depositions than is the norm, they're going to get 20 more from you as well. Is this the kind of case where you think that's good for you? You think that's bad for you? So there's no one size fits all in anything we talk about today. You really have to be thoughtful about your matter and devise strategies. And by the way, those strategies change often during the case. You think one thing early on, and then sometimes the strategy changes, but you have to be nimble, flexible, thoughtful. And it's not, I did this last case. I had 10 depositions last case. So for sure, I want 10 depositions this case. It's not, it's definitely not the way it works. You have to be thoughtful. I don't know, Justice Masley, if you want to add in on these at all.
Oh, just that the commercial division has its own set of rules. So we call the corporate representative witness an 11F witness, because that's the commercial division rule. And as Sandra said, you would delineate in the subpoena all the issues that you want to cover, and then it's up to the adversary to pick the right person or persons. And we also have rules on how many witnesses you can have. which is a very flexible number. So, every case is different. So we start off at 10 witnesses per side and then 7 hours per deposition. But, sometimes, you'll have a witness who will take longer for whatever reason. And, you just go to the court, either do it by stipulation between the parties, or you go to the court and ask for permission if the parties can't agree and explain why you need to go longer or you need more witnesses. With regard to experts and just discovery and depositions, generally, the court, we follow the CPLR in New York, and you need to get all this done before you certify to the court that you are ready for trial, which is a certificate of readiness. And once you sign that, in my view, and according to the rules, you're ready for trial. Discovery's over. So as Sandra is talking about all these things you have to do and you have to get it done, you need a schedule, and you might be working with the court on that schedule or just with the attorneys amongst themselves. Hopefully you don't need the court's intervention. Most people who do commercial litigation are able to do this without the court's intervention. If you do need the court's intervention, we're there. You can call and get a conference, or we'll get to it later, but you can call from a deposition if you need the court. So
I'm sure your favorite thing to get calls from the parties.
We don't get very many of them anymore.
I'm sure.
We used to get a lot more, but now that the rules have changed on numbers and questions, but we'll get to that.
We'll get to that. Okay. Now turning to, so what is the purpose of a deposition? And again, with everything, you want to be very thoughtful. What are you looking for, right? So sometimes you're really in, the discovery mode, the sort of figure out mode. I want to figure out, as I take this deposition, what the other side's case is, what those documents mean, what the events are, what's the timeline, what is that expert, what is that expert, going to opine at trial? And it's really important when you're in that mode to try to focus on closing out the witness. And what I mean by that, or often, sometimes it's actually, you don't want to do that. But again, tactics and strategy, but closing out the witnesses, you want to really know their full story, right? These are the four phone calls they remember. And there are not 2 other phone calls that when they get on the stand at trial, they're all of a sudden going to be able to talk about, right? So you really want to understand what they're going to testify at trial. And that's a perfectly, important part of depositions. Then there's also, you're developing your own theories / trying to get the other side to admit to something, right? And so some part of depositions is, I want to get an admission that I'm going to be able to tell the jury, when we get to trial, the other side admitted the following, or I'm going to be able to impeach the witness when he's on the stand by saying, by reminding him and the jury what he said in his deposition, and now he's sort of bound by that. So sometimes it's more sort of an open-ended, tell me everything, and you really want to make sure you close out the witness usually. And sometimes it's, to get admissions. And your tactics and strategy and approach obviously are going to differ depending on, what you're doing with the witness. And of course, you could be doing both, but your approach to the questions is different depending on, on sort of which one of those. And obviously, this is important to think about for offense when you're taking, and for defense when the other side is taking, and you're thinking about, well, are they trying to get admissions from my witness, or they trying to close him or her out, or both of them. And of course, another very, very key facet to depositions, particularly when there's video, but it's for you to evaluate whether your witness is going to be, likable, credible, believable at trial. So if you have someone who didn't do a great job in their deposition, they don't look very credible, they're obviously uncomfortable testifying, A, you're a little bit bound by, how they've performed in their deposition, but B, it gives you a little bit of a preview also of, how they're going to look on the stand in front of the jury, or of course, if it's a bench trial in front of the judge. So, that's definitely another key facet here, and particularly when there's video, you're a little bit locked in, with how they're looking and how they're acting. But that's just another key piece of depositions and the purpose of depositions. Okay, well, I think this screams for me, Justice Masley, to turn this one over to you, how the court uses deposition transcripts.
Right. So we use them, obviously, they're submitted on motions. And the first time I'll usually see a deposition transcript is a motion for summary judgment. If the case proceeds after the summary judgment motion, I'll see it in a motion in limine. For example, motion in limine is about what evidence is coming into trial. And you'll see that everybody makes motions to keep their experts, the other side's experts, out. And so I'll have the deposition transcripts for that. And we talk about, repeatedly about the local rules. So you want to look at the judge's rules to know in what, how are you going to put the deposition transcript before the judge. So I like mini script, and I like the entire deposition. Some judges want just the little section that the lawyers are talking about. So it's just something to keep in mind. You really want to know, because we'll, call you back and ask you to put in the entire transcript if you haven't done that. The next thing we wanted to talk about was supervising the use of the deposition testimony at trial. So the lawyers will get together before a trial, particularly jury trial, and they will piece together the sections of the deposition that they want to put before the jury or the judge if it's a bench trial. So that's something that, again, hopefully the lawyers agree to, and if not, the judge will get involved. And likewise, if you're using it for impeachment of a live witness, there will be objections. The court will rule on those objections, and that's really the way I would be involved with the deposition transcripts. I'm not really involved until the very end, basically.
Right. And obviously important, back to the sort of the purpose of taking depositions, to think about, with all of this, you have to know the rules of whether you're going to be able to force someone to come to trial or not, or is this effectively a trial deposition, right? If the witness is not going to be able to be forced to come to trial, or is otherwise unavailable, then that deposition will often be used as their trial testimony. So again, important to know that, because you might ask different questions if it's just sort of a setup before that person is likely to go on the stand, versus if that's it. Right. This is their testimony. That's it. And there's nothing else you're going to get from them. So that's your shot to use that deposition at trial, or that testimony at trial, and you're never going to hear from them again. And so, as with everything, important to understand where it fits and whether what's going to be what of this deposition is going to be used and usable. Okay. So I'm sure we'll come back to you here too, Justice Masley, but I think, as you said earlier, the judge will often set the ground rules for the deposition at the beginning of the case that, hopefully the parties mostly agree on the schedule that the judge will say sounds good, but obviously, it's up to the court to approve a schedule, and for the parties to abide by it or get relief of it if they need to. And as you said, often, parties negotiate, what the schedule ought to be. But of course, it's the judge's role to resolve conflicts about, how many depositions, how long the parties have, who can be deposed, and all fights relating to that.
So let me jump in there. So
Please.
on the resolves conflicts about who can be deposed, and also all of the conflicts. So the court is always available. For me, I'm available. My part's available by email if there's an issue, and you let us know, and we'll try to schedule a conference. So it's really through conferences and what are called discovery motions. So if the parties can't agree, and then you get to a conference, and even the court can't get you to agree, or the court makes a ruling at a conference. Although, let me just say as an aside, it's often the law clerks who are doing the conferences, and then they consult with me afterwards, and we draw up an order. And sometimes the parties don't agree, so they're going to then make a motion to vacate that conference order, because conference orders are not appealable. So that's how it percolates up to the court, the conflicts. The next issue, my favorite issue, is civility. If you didn't know, you should know. New York has civility rules, and they're not really rules, they're procedures. But you should be civil to your adversary and to the witnesses. And we'll get to that more at the end of the program today. But you should be aware of all the rules, the commercial division rules, the CPLR obviously is our procedure, but also these standards of civility, which often come up in the deposition context, because unfortunately everyone is not as civil as they should be. And when that happens, oftentimes, or actually before the rules changed, the commercial division rules changed with the limits on the hours and the number of depositions, we get a lot of calls. Now, we usually get calls about civility. And the problem with making a call to the court now is that I am not there. And so I'm going to ask you to play something back if it's a video, or I'm going to ask the court reporter to read something back. If it's video, I can see what happened and see how someone is asking questions. Usually the objection is that somebody's making speaking objections, or which is not permissible in New York. There are other places that may be permissible, but it's very hard for me to make a ruling. So what I see, the best way to handle the situation is to get through the deposition, ask all the questions you have to ask, get the deposition transcript to the court. In one case that we'll talk to at the end, they got the deposition transcript to me the next day. And then the court has something it can look at. I can't do it, based on, well, he's yelling at me, or interrupting the witness. I need to see it in the transcript. So I think people now realize that, and so we get a lot less calls. But the court is available, and having said that, you shouldn't use it. I had one recently where every few pages that somebody was threatening to call the court, which I would say is not the greatest practice. I can, if I hear the questions read to me, or watch the video, if you have an uncooperative witness, I can order the witness, and maybe that would be helpful to get the deposition going. Also, I can rule on questions. You really don't want to be calling the court on a question-by-question basis, though. Usually I would try to give you an idea of the kinds of questions that are going to be beyond the scope. And even if it is beyond the scope, so ask the question, get the answer or not, and then get the transcript in full to the court. You can always call back a witness. So the privilege issues are pretty serious, so that again, you get the objection on the record, and then come to court on a motion, and we'll sort it out.
Great. Okay, good. Well, I think I'm turning it over to Bob to talk about preparing to take a deposition.
Hi, everybody. I'm Bob Gretch in the New York office of Kirkland. It's nice to be able to speak to you today. I'm going to talk about preparing for taking a deposition. So as we talked about earlier, in most cases, there's a limit on the number of witnesses that the court will allow a party to depose. And so you need to first to think about who's important in your case. And I encourage you to start by putting together an order of proof. And that's really just a checklist of every claim and defense that you are that you have at issue in your case, and every element of every claim and defense. And early in the case, you're not going to know everything, but you're going to know some stuff. And you should start populating that order of proof, that checklist, with where you're going to get your evidence on every claim and defense. And that's going to help you decide and sort of triage, who gets deposed and who doesn't get deposed. It's very common for there to be more than 10 witnesses. I know that 10 is a presumptive limit, but there's usually more than 10 people who know something about your case. So think about which witnesses are likely to have the most knowledge, which witnesses are likely to have unique knowledge that you actually need to prove up a claim or defense. If you have a witness who has limited knowledge, or maybe a third party who knows one or two things, but who's not a key player, maybe you decide that an affidavit is good enough and you don't really need the full deposition. And as a last resort, as we discussed already, if you really have, more than the court's presumptive limit, you really need them, then you can go to the court and ask permission for additional depositions. And, you'll have to explain why they really are necessary, but that is the kind of thing that courts deal with frequently. So planning ahead, it's very important. You want to get everything on the first shot. It is possible to depose a witness twice, but it's not common. And it's really not common if you're talking about questions that you could have or should have asked the first time you had that opportunity. So you really want to start by understanding the facts of the case, understanding the law that applies to the case. This goes back to your order of proof. What are the claims and defenses? What are the elements? Jury instructions are very helpful here. Figure out where the witness fits in, and then what discovery do you need from this witness? So, really three sort of categories here. Sometimes you're just in pure discovery mode. You're in fact-finding mode. You want to know what the witness knows. The second thing is clean admissions, right? You want to get very clean, concise answers on key issues in your case. And you may have to try more than once to do that, right? If in your case you have to prove that the stoplight was red at the time of the accident, and the witness gives you a sort of long rambling answer about what color was the stoplight, you have to think ahead and think, am I going to be able to actually use this answer in a summary judgment brief or in a cross outline? And if you can't, then you might want to go back and get it again and say, Mr. or Ms. Witness, my question was the light red at the time of the accident? And then get your simple yes or no answer. The third thing you might want to do is closeouts, which is to exhaust the witness's memory on key topics to prevent surprises at trial. You always want to prevent surprises at trial. You want to know everything that the witness could possibly say at trial, especially about key topics. And so you really want to end lines of questioning with, is there anything else you remember about this event? Or have you told me everything you remember about such and such conversations? Or were there any meetings between the two of you that we haven't discussed today? And really get them to commit that they've told you everything.
Just on that topic, I had a motion today where it seems that they may not have closed out a witness. And as a result, 18,000 pages of discovery came to light after the note of issue was filed. So that's even before trial. Right after the note of issue, it came to light as a result of the expert reports. And as a result, now they have to go back and vacate the note of issue and start doing discovery about those 18,000 documents.
So when you start your prep, start by understanding who the witness is. What background information can you get from a simple Google search, right? Where does the witness work? What is the witness's educational background? Does the witness have a legal education? This comes up a lot. You might assume that it doesn't. You might assume that, everything a lawyer does is privileged, so they never get deposed. That's not true. Lawyers get deposed pretty frequently. If the lawyer is practicing and advising their client in the context of the case, then there may be very limited things that they can answer questions about. But oftentimes you have somebody who's a lawyer by background, and who, has knowledge of the case that is not privileged, and that person may need to be deposed. Lawyers tend to approach depositions differently from non-lawyers. They answer questions differently oftentimes. And so that's one thing you might want to consider. Also consider how the
Can I
witness
just stay
fits
on
it.
that topic?
Yes.
I have 2 motions to disqualify today because lawyers are potentially witnesses in cases. So it happens.
Yeah. And think about how your witness, the witness you're preparing to depose, fits into the case. Some witnesses, know a whole bunch of stuff about the case, and you really have to triage what you're going to cover in your 7 hours. Other witnesses, are maybe key witnesses on the very specific events, and you can go a lot deeper into those events. But you have to sort of figure out the universe of what the witness might know. And then the next step is to create an outline. Identify the events that the witness is likely to have personal knowledge of. Again, you don't know everything that they know, but at the time you're creating an outline, you've probably seen a lot of documents in the case, and you have an idea of where people fit in. You want to identify certainly all key documents in the case that your witness authored, sent, or received. You want to get the witness's testimony about those documents, and then start your outline. Everybody makes their deposition outlines differently, but for the most part, everybody needs some sort of outline. Sometimes you may want to ask your questions in chronological order from the beginning, of the relevant facts right up to the present day. Sometimes you might want to ask your questions in a more thematic organization, and that's a total case by case thing, and it's also to your preference. And then again, before you start the deposition, go back and look at those claims and defenses, look at the elements, look at the jury instructions. Do you have a plan to get everything that you need from this witness? Because again, assume that you're only going to get one shot. And then the boring stuff, the logistical issues. This is really important. Reserve conference space, don't be the person who assumes that somebody else is doing it. Make sure that it's actually getting done. Don't have people show up and there's no room for them to go to. A court reporter and videographer also, make sure that those are booked. You should usually ask for a live note. I don't know how anybody deposes anybody without a live note, but that's to preference.
Can you tell us what that is?
Yes, sorry. A live note. So the court reporter creates a verbatim transcript, and that's actually a little bit of a process. It takes them normally a few days or a week to send you, a precise transcript. But what they can do in real time is they set you up with like an iPad that has a rough transcript in real time as the witness is speaking. And it's got, some typos and it's not perfect, but you can see how your questions look on paper and how their answers look on paper. And that goes back to this idea of clean admissions, right? It's hard to do this mentally in real time while you're in the middle of asking questions. But if an issue is key in the case, you want to know that you got a clean answer, an unambiguous answer from the witness, if at all possible. And it's much easier to do that when you can see a rough draft transcript right in front of you as you speak.
Just as an aside, I use the same system. Usually for trials, attorneys will order the same system for trials, and certainly makes ruling on objections a lot easier.
Right.
Time-saving tip, order a catered lunch for your deposition. Sometimes you're getting really down to the wire on 7 hours, and Sometimes there's arguments on, does lunch count? Does lunch not count? Was lunch too long? Whatever. If you just have some sandwiches and sodas brought in, then you can keep things nice and short and keep things moving. Make sure everyone knows the start time, right? So the way that depositions work is you'll send out either subpoenas or deposition notices that say, it starts at 9 a.m. at 601 Lexington Avenue or whatever it is. And then the deposition is months later, right? It's really helpful just, the day before to remind everyone, hey, we're starting at 9 a.m. tomorrow. Reminder. You don't want somebody showing up and saying, oh, I'm sorry, I thought it was 9:30, and then you've wasted a half an hour. So that's just an easy thing to prevent. You also need somebody back at the office, ideally, who can help you if you need something. If the witness, mentions some key document that you didn't bring a copy of because you didn't think that this person was involved, or whatever it might be, you want somebody back at the office who you can send a quick email or text to during a break and who can help you out with things like that. Last thing is review the rules. I mean, ideally, you'll have looked at the rules before you're about to head to the deposition, but it's not a bad idea to check them one last time. So there are obviously, the federal rules, but every court, every court has its own local rules. And there may be rules on depositions that you want to review. And then individual judges within court systems often have individual practices, usually on their website. And you want to review those too, just to make sure that there's, nothing that you haven't planned for. Review any discovery orders issued in the case. Okay? By the time you're taking depositions, you will have discussed discovery with the court, at least once or twice. There's probably one or two discovery orders in the case. Are there any topics that the judge has already said, are out of bounds, right? If so, remember that. If there's going to be a dispute about whether a topic is proper or not, have some sort of a plan for what you're going to do in real time if the witness, perhaps refuses to answer a question.
Can I jump in on the
Yes.
On the rules? So the commercial division rules are modified from time to time. And so your tip to check the rules is a really good one, particularly if you're practicing in the commercial division. And, the individual judges, I would say my colleagues and I don't change our individual practices too often, but that's a really good thing to check and make sure. I recently updated all of my trial practices, and we sent them out to all the upcoming trials, but it's just a really good practice, and I really like that tip a lot. So thank you.
All right, now we'll talk about taking a deposition.
All right, thanks, Bob. Hi, everybody. My name's Stefan Atkinson. I'm also a litigation partner in the New York office here at Kirkland, and it's nice to be speaking to you all. Okay, so taking a deposition. We have our final two sections here are on taking and defending, because as Sandra said, they're different beasts, entirely kind of different processes, lots of different considerations as you go along. So I'll start with taking. And then we'll get into defending. So when you're taking a deposition, just be ready, right? This is your sort of show, as you might say. The lawyer examining the witness is very much in the driver's seat when it comes to the deposition. The questions that are asked, the pacing, how long the day goes, all of that, what documents are shown to the witness. These are all things that the examining attorney essentially manages and controls, him or herself. And with that comes great responsibility. That is, it is your day. And so you should be responsible for every element of it to make sure everything goes smoothly. So arrive early, right? You don't want to show up to your own deposition, right on time, or God forbid, 5-10 minutes late. arriving with a flurry of papers and having things just generally be disorganized. Show up early, be in your chair ready to go before the scheduled time. Introduce yourself to the court reporter and the videographer. It's not just good manners, it's good to have a rapport with the folks helping to make sure, again, that your deposition, the thing you're responsible for, comes out great in the end. Look at the video.
Sorry to interrupt, but I would
Sure.
say, introduce yourself to the witness too.
Yes, absolutely, and shake their hand and develop some kind of, personal rapport with them if you can. What's the saying? You attract more bees with honey than with vinegar. I think some lawyers, unfortunately, view every deposition as a war. Every case is different, but more often than not, in my experience, you end up having a more successful deposition if you have some kind of conversation with the witness, if you're able to develop a rapport. So absolutely, go up to the witness, say hello, introduce yourself, shake their hand. 100% agree with that, Justice Masley. But back to the video and the court reporter and so on. You can go over to the videographer and ask nicely to look at the screen and see what the shot is going to look like. Make sure the witness is in the middle of the box, right? Make sure that there isn't, some open laptop in the middle of the screen blocking some of the view. Make sure live note is working. The court reporters are typically very patient, very helpful, happy to run through, a quick practice with you in advance to make sure everything works. Make sure the room is arranged appropriately. Everyone can hear the witness. If there's coffee or water in the room, make sure it's not right behind the witness, because then anytime anyone gets up to get a coffee, they will be in your shot. Have it up over on the side. I mean, these are little things, but they can make a big difference.
Let me just jump in again. You've described the perfect situation where you're taking the deposition in a known space, probably an attorney's office, but you should know that the CPLR provides that you can, you take the deposition of a witness where they reside or they have an office or the county in which the case is pending. So, you could potentially be, in another country or another state, where you may not have an office. So you have to make those arrangements too. If you're in the courthouse, which is probably not a good thing because that means people are not getting along and the court feels it needs to be present for the deposition. And it certainly has happened when I've had, unfortunately, lawyers threatening each other. Then I'll have a deposition taken in the jury room and, with the door open and a court officer handy. If it's a government employee, they get to take you have to take their deposition in their office. I mean, they may want to come to your office and have the lunch and all of that, but the first option, and they have the right to have the deposition in their office. So just some other things to think about. And then, of course, you can have virtual depositions too, where some other things will apply, like where is the person, who's present. The court has some questions that you might ask before we start virtual proceedings. You could use it for a deposition too. It's a list of questions. Who else is in the room with you? Is anyone in the room with you? Will you tell me if somebody comes in the room with you? If somebody texts you or tells you, and I think this goes even for your depositions in person, do you have a phone with you? Where is the phone or the laptop? You don't want witnesses getting coached, right? With their phones. I had a witness during a virtual trial, and someone heard the Slack noise, that a Slack message had come in, which I didn't recognize at the time. But we had to stop and go through all the questions again and make sure that no one was being coached.
That's a great point. And look, over the last several years, I think all of us unwittingly have gotten used to taking virtual depositions over Zoom. I mean, one thing you have to think about, particularly if you've never done it before, is how you're going to show documents to the witness. There are a lot of the companies that provide, court reporting and videography support will have means by which you can share documents on the screen. But like with any software program, those can have bugs. They can crash in the middle. I mean, I've seen lawyers get very creative. One thing I recently did was I sent a box of documents by FedEx the night before to the other side. And we had an agreement among the lawyers that they wouldn't open the box until the deposition began. And that way we avoided, relying on the technology, and we just, had the documents. I had paper in front of me. The witness had paper in front of them far away. That's
what I do for
requires
trials also. Sorry to interrupt, but that's what I do for trials too. I always have a set of paper documents, even well, I do it for the in-person too, but for virtual especially, so we don't have to take up another screen, or I want to be able to see the witness all the time. So I don't want a screen taken up with documents.
Right, absolutely. Okay, so on to the next slide. I'm going to move things along a little bit because we want to make sure we give you our thoughts on defending too. But this one applies to both. Be professional. If you lose your cool, if you act unprofessionally, if you're rude and discourteous, it will not age well, particularly on video. You will regret having acted that way. And not only is it, as I said before, bad manners, it's often bad strategy. If you start screaming and yelling and waving your arms at a witness during a deposition, the human impulse may well be to shut down, and you are not likely to get the best testimony. I often say to witnesses when I'm preparing them for a deposition, in other words, when I'm defending, remember it's not a conversation. And the other side of the coin is when you are examining, often the best strategy is to have it become as much of a natural conversation as it can be. Almost have the witness forget that it's a deposition, because they tend to, you tend to speak sort of more freely in a more informal setting. So that's just one thought, but it's important to be professional too, because you have you are a professional. You don't want Justice Masley or another judge to see you behaving badly and embarrass you or sanction you or anything else like that. But also just in terms of strategy, it often is not the best way to proceed.
Yeah, or worse, when they play the video before the jury.
Absolutely, right. So again, the warning is it doesn't look good. It just doesn't. Another point, often jokes don't go over well in depositions. They aren't really very funny, and sometimes they are worse. So just another thing to keep in mind. Just very briefly, I want to talk about the funnel technique. So Bob mentioned this. It's really related to closing people out. The idea of the funnel is you start broad and then you narrow down over time. So you start with open-ended questions where you get the witness talking, and then you seize on particular things that the witness said to try to learn as much as you can about the topic in question. And then, as Bob said, at the end, is there anything else? Have you not mentioned anything, other things? Were there other meetings that you attended? And that way, if they show up at trial 6 months later and start talking about a meeting that was never mentioned at their deposition, you can effectively impeach them by saying, I asked you about any other meetings and you didn't mention it, did you? Right? So you want to close things out because you don't want surprises. It does say always close out the witness. As Sandra said, always is probably not the right term. Sometimes if it's a trial deposition where the witness will be unavailable, you may not want to ask that final, is there anything else kind of question. Every case is different. And I will say most of the time, you want to close out the witness to avoid surprises. I think this slide is probably pretty self-explanatory. Let's just go to the next one, because the next one's just about the mechanics of introducing an exhibit. So there is a script. And you should write down, particularly if it's your first time doing this, write it down. Write down exactly what you're going to say. I'm handing the court reporter a document bearing production number or Bates number blank. We've marked it as exhibit X. Then you hand out copies. Make sure you have 5. I always say 5 copies of every document that you bring to a deposition. So the court reporter has one, the videographer has one if they want it, the lawyer on the other side has it, of course, the witness has it, and then you just have an extra one to make you feel good about it. And then you ask questions about the document, and then when you're finished asking questions, you say, you can put that document to the side. This point beside number 3, always refer to the document by exhibit number. That's absolutely critical, because remember what we said earlier about how depositions are used. It's not the full deposition transcript that gets played to the jury or that gets used in impeachment. It's the little vignette, right? It's the Q and the A. And if you say this document, that email, and your Q&A is not self-contained, there's going to be a lot of confusion in the record about what you're talking about. So it's unnatural, but try to say exhibit 5 every time you reference the document. And then finally, be ready for surprises. You have to have an outline. You'll run the risk of missing things if you don't have an outline. An outline will also allow you to ask really smart questions that you had time to think about, but you should listen to the answers. The answers are often surprising and interesting, and they lead to other lines of questioning. A lot of the most valuable time you spend in a deposition is sort of off script. It's based on something interesting the witness said. So listen, it is in a sense an interview, and just like every other good interview, the interviewer should be listening to the answers and not just sort of plowing ahead through their outline. It's probably an obvious point, but particularly if you're nervous and you haven't done it before, your outline is going to make you feel secure and safe. Try to fight the urge to stick to your outline no matter what. Okay, Sandra, defending.
We're running out of time, but I just want to jump in before we get to defending, because as the person taking the deposition, it's your responsibility to get the transcript to the witness. And you're going to want to do that, because if you don't comply with this rule, you cannot use it for the summary judgment motion, the motions in limine or trial. So if they don't sign it, okay, then you can use it, but you have to send it to them. And then there's a certain period of time they get to sign it. And I've seen now a couple of times recently people trying to change testimony with an errata sheet. You can't do that, of course.
Right. The errata, just so everyone knows, that's an opportunity for the witness to make kind of clerical corrections. Like, hey, I said, true, not blue. And the court reporter wrote it down as blue, right? That's what it's intended for. But as Justice Masley says, sometimes they try to change the substance of their testimony, which is a no-no.
Okay, terrific. So now we're on to defending depositions. And a lot of what you heard Stefan talk about, you have to think about for purposes of defense, because Stefan just told you, he goes in and he feels like he's in charge and he's taking the deposition of your witness. So put yourself in the shoes of what your witness is about to face is thing one. And thing two, of course, you have to think about substantively, what is it that Stefan wants to, depose my witness about? What are they going to want from this witness in order to help prepare the witness? And likewise, what do you need the witness for at trial? Or do you need the witness at trial, right? It may be a slightly different preparation depending on the answer to that question. But bottom line, any witness needs to be prepared before they're being deposed. They can't just walk into the room, sit in the chair and answer questions. You need to explain to them, and understand, again, put yourself in their shoes. Even the most seasoned executives, understandably, get very nervous before they're about to be grilled for 7 straight hours at a deposition. So explain to them visually what the room is going to look like, who's there, what happens, what it's all about. So you start to sort of take away the unknown for them as to what, what it's all going to be about, and they can start to visualize, what's going on. But very, very importantly, you have to go through and ask them what they remember. And this says ask, and that's really important. You have to ask. A lot of times lawyers make the mistake of sitting there and telling their witnesses what they think the case is about, what they think the documents show, what they've learned. Lawyers sit there and tell them their view. Not the way to do it, because that's just, the witness comes with a certain perspective. Always put yourself in their shoes. Witness comes with a certain perspective, and you're telling them what you think A, is inappropriate, but B, is not, they're not going to remember, they're not going to sort of remember the events by hearing from you what you think, right? So they really need to talk. You need to hear what they recall, and certainly sometimes you have to refresh their recollection with documents. But they really need to talk through what they remember and not hear you just talk about it. You do want to do mock questions and answers with them, as they're walking through, or after they've walked through what they remember, what kinds of questions, Stefan might ask them. And so they start to understand how this might go tomorrow, or whenever they're deposed. But it's really important always to be mindful of what perspective they're coming in with. A lot of folks come in, seeing it over and over again. A lot of witnesses come in and they think the right approach is they're going to be belligerent. They're going to sit in that chair and sort of say yes, no, or I don't know, and be very belligerent. And that's not the right approach. They need to, first of all, most importantly, just be truthful. And second of all, a lot of the times they can't say, I don't know, and then at trial all of a sudden remember everything, right? So if you need them to be a trial witness, if they're going to be a trial witness, you have to explain to them that just saying, I don't know. First of all, if it's not truthful, that's a problem. And second of all, it forecloses them from being witnesses at trial. And a lot of what we do is about showing that you're, a good executive, you're functioning well. You have to have good judgment. You have to be open. You have to be credible. And I think a lot of times folks come in having seen on TV, or heard their friends talk about, oh, I went in there and I just killed it. They don't have the proper perspective, and it's your job to explain to them the seriousness of this and make sure that they know everything they need to know before they go into that deposition. So in terms of defending deposition, like Stefan said, you also want to arrive early with your witness. You don't want to be rushing in and have the witness all nervous. Very important to explain, frankly, before, but also during the logistics, when they can take breaks, how that all works. Because again, Stefan says he's
on that issue, I'm just going to jump in.
Please.
Because the court will issue an order called a protective order if your adversary won't agree to it. So if you have a client or a witness who has health issues, or, we see a lot of back problems, like you can't sit for 7 hours and get your deposition taken, you need to stand up. If the parties won't agree to it, though, frankly, most lawyers are aware of this, they'll agree to take a break every, half hour, 2 hours, so the person can stand up, taking breaks to use the restroom. Like, there are health issues at times that maybe you have to limit the deposition. I've had this, to an hour or 2 hours, and then come back a week later or something like that because the person can't handle the stress or whatever. So the court's always available to do that. Of course, to get that kind of an accommodation, you need some proof from someone, usually it's a doctor, saying why you need this accommodation.
Right.
So we have 1 minute left, and I really want to show the video.
Okay. All right. So this is an example of what not to do as a witness or as a lawyer.
You got Selena Gomez? Yes. You'll be dating her at some point in time?
What's the relevance of that? Why are you asking that question?
Because I'm allowed to ask.
No, you're not allowed to just make
absolutely
up ask it. What are you talking about?
It sounds like you're trying to harass him.
Be a lawyer, man.
Stop making journalism. This isn't journalism.
What is the relevance? What's your pro?
Have you ever,
What's your
if
pro?
you have an objection, state your objection.
What's your pro offer of relevance on that?
Sir, have you ever talked with Selena Gomez and discussed your feelings about paparazzi?
Don't ask me about her again.
Sir,
Move on to another.
have you
Don't-
ever,
don't ask me about
have
her
you
again.
ever
Don't ask
discussed,
me about her again.
have you ever?
Don't ask me about her again.
discussed your feelings
Don't
with
ask me.
Selena
Don't ask me about her again.
Gomez about paparazzi?
You know what? Just stop.
Don't ask me about her again.
The client's not asking for a
Don't ask me about her again.
Let's take a break.
Not a good look by either the witness or the lawyers. And Justice Masley, I know you've experienced some of this in some cases, so I'll let you get the last word in here.
Oh, just, if you have that experience, I said it before, I'll say it again. Get through your questions, get it on the record. And if there is bad behavior, the court will entertain a motion for sanctions. I have in the past, and frankly have another one before me right now. It's happening more and more. But the court can appoint a special discovery master to sit in to complete the deposition, which is what I would expect to happen in the one that we just saw. I have been known to sanction attorneys, a financial sanction, a sanction to a charitable organization. I have also ordered civility training. You don't want to be getting such an order. So I think that based on all the tips you got today from this incredible panel of litigators, you're ready to go. Just prepare for your first deposition and follow their directions. So thank you all so much. I just want to remind everyone there's 2 more programs left, one on electronic discovery June 20th and trials on June 27th. Thank you. Thank you so much to the panel members. It was really a pleasure working with you today.
Thank you very much.
Thank you.
We're done.
Thank you.
Bye-bye.
2 minutes over. Okay. Thank you.
Thank you very much.